whether our contention, the balance of our contention, is considered moot, and we wait around to see what the information, assuming we get access to it and we can evaluate it and so forth, and then we do another contention, or whether this panel simply says we're going to hold that in abeyance for now until the petitioners get an opportunity to see the information that's been filed and amend their contention accordingly. Procedurally, probably doesn't make very much difference, so long as we get access to the information that we need to make that evaluation. In our papers, I believe what we suggested is the latter, that you not find that this contention is moot, but rather find that the original contention, as bifurcated under the staff's analysis and the applicant's analysis, bifurcated one to say, was the information in the original documentation? I think there was an agreement implicitly that it was not, making the contention germane. But then the substance of the information, having now been submitted, renders the contention moot. We would prefer that you just not make a ruling on that mootness argument now until we do have an opportunity to address the new information and submit that evaluation to this panel for its consideration, and then make a determination as to whether or not the contention should be admitted into the full adjudication.
First of all, Judge Arnold, I have been authorized by my client to say that our 52.80D report does not deviate from the design control document. So at least we can tell you that much. With respect to comments by petitioners that you perhaps hold this contention in abeyance pending their access to our report, again, I think the case law is very clear that the appropriate process is to dismiss the contention as moot and then enable the petitioners as warranted to raise a new contention based upon the new information that we've submitted.
The only problem about holding it moot at this point is that we don't have access to the information that you submitted at this point. We have not been provided it. And I'm not sure that, I mean, in one sense it seems to make more sense to just hold off until the decision has been made and if necessary appeal and another decision made on access before ruling on the contention as a whole. I mean, there may be some parts of it that could be separated out, but in looking at it, it almost seems as though those are not part of the contention itself, they're part of the argument in support of the contention. So I guess I'm not following how we would rule that it's moot at this point.
You do have representation by counsel for the NRC staff that they have reviewed our report and find it essentially to be equivalent to adopting a decision where they found it to be sufficient for their further review.
I'm not sure that that would lead us to automatically do that.
No, but I think given that representation by the staff, that's a sufficient basis for classifying it as moot, with the realization that petitioners can always submit a new contention based upon the content of that report once they have access to it.
Well, unless you gave me some specific authority that we would rely on the representation by the staff in the absence of seeing the information on which a mootness determination were made, I don't see how we can make that.
Yeah, I would suggest then, because it is with the NRC, that I believe the board needed access to that document if they want to.
Yes,
and I'm not sure the board would want to, at least. I'm not sure that I would feel comfortable making a determination based on information all parties did not have access to. Is there really any reason not to hold off on this?
Well, right now, both the applicant and the NRC staff object to all the contentions.
Is there any reason to support your objection? And is there any real practical reason why we shouldn't hold off on making this ruling until all parties have access to the information on which the ruling would be based?
Yes, because we believe that the parties, that the petitioners have not satisfied the requirements for admissibility.
What is the practical impact of holding off on making the ruling?
Judge, if I may.
Hold on.
Yes, Judge.
Hold on. What is the practical impact of holding off on making the ruling?
The practical impact is that the petitioners then essentially have party status, and you admit them as interveners. And that's the practical harm to us.
Well, I'm not sure that you can even say that at this point, but in any event, do you have any support for the argument that an adjudicator would make a ruling based on information that one party does not have access to, and on which there's been a request for access, and the determination on which has not yet been made? I mean, I think that would go beyond any normal understanding of what adjudication consists of.
Well, there are oftentimes NRC staff determinations that are not subject to review by the board.
But that one is.
And what I'm suggesting here is that, for example, the staff determination on docketing can be accepted by the board without further review. I think this decision also by the staff that the report that we've submitted is sufficient for their review under the rule. That should be sufficient for rendering this contention moot. If the NRC staff does grant access to SUNSI, would the board then feel free to rule that this contention is moot?
We began our questioning asking what the ramifications of what you have filed are. I think that at that point, and from my view, it would make sense to get the parties' argument on whether or not it's moot after they've gotten access. We could hold a